স্বাগতম সকলোকে আমাৰ ইউটিউব চেনেলটোলৈ নিশ্চয় সকলোৱে ভালে আছে যিসকলে 5550টা পদৰ NIOSৰ ডকুমেণ্ট ইলেকশ্যনৰ বাবে কোৰ্ট কেছ কৰিছিলে আৰু আজিৰ হেয়াৰিংটো যাতে শেষ হেয়াৰিং হ'বলৈ গৈ আছে সেয়েহে আপোনালোকে ভিডিঅ'টোৰ জৰিয়তে সম্পূৰ্ণ জানিব পাৰিব যিহেতু মিষ্টাৰ কালাৰা আজি হেয়াৰিঙত উপস্থিত থাকিব পৰা নাই যদিও তেওঁ অনলাইন যোগে হেয়াৰিঙত আহিছে আৰু তেওঁ অনলাইন যোগে আৰ্গুমেণ্ট কৰিছে প্ৰথম পৰ্যায়ৰ আৰু নেক্সট পৰ্যায়ৰ 2টা বজাৰ পিছত হ'বলৈ গৈ আছে আৰু আজিয়ে NIOSৰ কেছৰ শেষৰ হেয়াৰিংটো হোৱাটো সকলোৱে বিচাৰে আজি এটা সমাধান আহিব বুলি সকলোৱে অপেক্ষা কৰি আছে আৰু প্ৰথম পৰ্যায়ৰ আৰ্গুমেণ্টৰ আপোনালোকে দৃশ্যটো এতিয়া দেখিবলৈ পাব কি আৰ্গুমেণ্ট কৰিছিলে মিষ্টাৰ কালাৰাই তেতিয়াহ'লে আমি চাওঁকচোন
May I please go out? Am I not able to hear me?
Yes.
Yes.
Before my learned pen starts, Lordship was pleased to direct us to give the note on the dais. I am giving a detail. So that is the only part we have to do, Lordship.
Are you placing the note? Can I have a copy? Oh, yes.
Yes, who's appearing for the petitioner?
Sir,
That's
Mr.
for the petitioner.
Karla is online.
Yes, Mr. Kalla, yes.
My
Sorry for appearing virtually, my lord. I try to assist in this form, my lord. My lord, I prepared a short note for today's hearing, my lord.
Yes.
This
My
sum
note will
my
be- This is just a reply.
Mr. Saika, no problem. If anything is required,
No.
only Mr. Chiste, I might, you may just have to show me that because I remember Mr. Saika the other day had drawn the attention of this court to the initial order from where this relaxation comes. So that you will have to give me that once because I was reading the file yesterday. I couldn't locate that particular page. Too much of pages are there.
No.
So
This is my
That
lord.
is 2015
Yes.
something from the petition, if I'm not wrong, you had shown.
from the judgment.
From no, there was one annexure, perhaps
I will show that,
Yes,
my lord. I will
yes.
show that.
that particular document.
He will.
It's all right. He will give it. I'm just indicating so that he has it. Yes. Yes, Mr. Kalra, this is your additional notes rejoinder. Okay.
The note based on the submissions that were made by the state on the last date of hearing. If my lord would just have that this note is into 3 parts. I'm just giving a background, then I'll take my lord through each and every argument that I wish to advance today. The first part is the argument that have been taken by the state for the very first time in the counter submissions on the last day, which are not a part of the counter affidavit. So the first heading at page 1 refers to those 7-8 submissions that have been made for the very first time. And my lord had pointed out to me the other day that fresh arguments may not be accepted. Of course, I put in some judgments to show that yes, fresh grounds/defenses cannot be taken. Still, I will try and make an attempt to answer those. Then, my lord, at page 2 bottom,
Page.
are the judgments on each proposition of law that my lord will have to consider. Page 2 bottom, on each of the
Yes.
propositions that I could think from all these days. For each proposition, there is a judgment along with those relevant paragraphs that I have mentioned.
The first judgment is this state of UP.
Indeed, my lord.
So that is on what point?
If my lord would just have the italic above state of UP, which says representation to state authority,
Sorry.
just the italic above.
Just 1 second, Mr. Kalar. Are you familiar with this?
Yes, my lord.
I think you can just take me through this note because I'm finding difficulty in understanding Mr. Kalra. Mr. Kalra, just here I'm requesting the
Mr. Day.
Mr. Day to just take me through this note that you have filed because your voice is not very legible. If some more clarification is required, we'll come to you.
Can I just
Okay.
make a request, my lord?
Sorry?
Can I just make one request?
Yes, yes.
Would my lord consider requesting the court master to increase the system volume? Or if the system volume can be increased, my lord, my voice will be clear.
Oh, volume is there, but I think there is some. Can you hear clearly? I'm not being able to hear very clearly. Anyway, this part, Mr. Day, na?
Mr. Day.
Mr. Day can also do. Yes, Mr. Day, the
my lord,
first decision is on what point?
On the representation, my lord was asking on that day whether this 170 people had filed a representation before approaching this honorable court.
Okay.
My lord, The first note is on this, my lord.
Hmm.
The second is on the same
And
point.
that the paragraph is 10 and 11.
My lord, the
So
paragraph.
even without representation, it can come. That is on that.
My lord, that has been
Okay.
my learned friend has shown that.
Have you given photocopies of these decisions?
My lord,
Yes, my lord, we have made a
Will you
compilation.
please provide
I'll-
photocopies of all the decisions, and in those photocopies that Mr. Day you provide,
my lord,
you just
Mark.
highlight that paragraph. Huh?
my lord.
Yes.
My lord,
Next
the
is
point
Whirlpool. Yes, Whirlpool is that alternative remedy, or on what point Whirlpool?
My lord,
The next case, representation only on that is also on
that
representation.
is on the also on the representation, my lord.
Representation. Okay. So two
The-
cases on representation. Then number B,
B is also similar, my lord.
representation. Okay.
C
There
is 162.
Something to add in B. There's some. Am I better audible now?
Yes, I will. You say. Let me try.
Yes. In
Yes.
point B is regarding interpretation of a court order. My main ground in the writ petition is that because the Honorable Supreme Court's order is not being rightly interpreted, therefore a representation is not required. That is another ground.
Sorry, but come again. On the apex court judgment is not.
Being rightfully interpreted.
All right. All right.
So therefore B is on the fact that once wrongful interpretation of a court order is looked into, then a representation is not mandatory.
Okay. Noted.
Then C is regarding Article 162. That merely an aid of Article 162 cannot be taken without there being a reference in the impugned notification or as a defense in the
This
counter.
is basically for changing of game of rule. Only on that 162 will not help. Correct.
162 is on the statutory backing, if my lord would recall.
No, I understand, but you mean to say that by doing that, you can't also change the game of rules.
No, there is slightly different. There is some slightly different argument there. I have challenged the competence of the impugned notification. The impugned notification, as per the state in the counter, can be on two grounds. One, there is a order backing, and one, there is a statutory backing. For the order backing, I have said that the Supreme Court order does not in any manner say. On the statutory backing, the learned AG last time argued that this is covered under 162. In answer to that, I have said that 162 will not apply because the impugned notification does not refer to 162.
Okay.
Or
Okay.
the minutes of meeting while passing this notification does not refer to 162.
Followed.
So therefore, it is on the statutory backing.
All right. Yes.
And then D. I say that introducing new documents amount to change of rule of the game.
Okay.
New documents cannot be brought in. They can
All
very
right.
well.
No, all right. Noted.
And then E is another separate argument where I say that the primary document has not been doubted till today. It is
This
no
is
one-
that for this you're relying Doli Chanda.
Yes, Doli Chanda, my lord. Unless the primary document is questioned, doubted, till such time the aid of secondary documents cannot be sought. There has to
All
be
right.
first an averment or a doubt on the primary document.
Followed.
And then
Yes.
we see F. F is the after effect.
Consequences.
Yes, the consequence of an additional document cannot lead to me being rejected from the recruitment process. The consequences of 6 additional documents that are being sought, if I have 5 out of them, 4 out of them, the consequence cannot be to reject me or remove me from the recruitment process. At best, it could be to ask the school for some additional documents. The effect of non-providing a document, because my lord, what
At that stage, Mr. Kalla has not arrived. We are now we are considering a hypothetical situation that you will not have these documents, and suppose you don't have these documents, the state cannot simply not consider your case. This is what you are trying to say.
The answer is this, my lord. At the time of filing the writ petition, the state that had not arisen, but now it has arisen because in the merit list which has come in, most of us are not there.
No, that's because okay. So you are saying that even if you do not produce these documents, they cannot withhold your case.
Indeed,
They have to consider your case.
Indeed, it cannot be a mandatory they cannot be mandatory in nature. They can at best be guiding in nature. They can at best be explanatory in nature. They can't be mandatory in nature. Plus, can all of them be mandatory in nature? So this case, which I refer at para F, talks about the fact that yes, you want verification, ask for one, ask for two, ask for any of the above.
Okay.
And then G, my lord, there was another oral objection taken by the learned AG last time that multiple petitioners cannot challenge in a common writ. So G satisfies this, that if the cause of action for multiple petitioners is same, then it can be challenged. And then 3 onwards, my lord, are the concealments to which state has not replied to till date. So these are the 3 main headings of my today's argument. So if my lord would permit, can we start from 1 now? I will just take 1 minute on each ground. I
But
just
you have already, I have heard you in this. So basically, now you're just supporting it with the judgments. Only thing I would have appreciated if these photocopies were here, then I could have just checked the paragraphs once.
I'll give it to you.
well, the photo
But
by
you
the
don't
end of
have
the
it
day,
right now.
yes,
Photocopy should have been kept ready.
it is being made.
Then it would have been easier for the court to appreciate in what context these have been held.
Yes.
But they are just being printed. By the end of the day, my lord will have it. When we'll
So
flag it
that
also.
is after finishing your argument, then you see the whole exercise becomes very unnecessarily wasteful.
Can I then request one thing? I understand.
I would have appreciated it since you are relying in so many decisions. At least photocopies. This is the practice we follow in this court.
Can I request something then? I will
Yes.
start on with my arguments. Meanwhile, because this will spill over post lunch also, once the Honorable Court assembles post lunch, the copy would be ready.
No, then at 2 o'clock.
Very well.
Like this, not in this piecemeal manner.
Very well. Very well.
At 2 o'clock, you have
I'll
the
have that.
judgments ready.
Very well.
At 2 o'clock or at 2?
Very well, my lord. At 2 o'clock is good.
That not bad. Yes.